Ever found yourself lost in the world of research, wondering what path to take? You hear terms like doctrinal and qualitative thrown around, and they sound complex, maybe even a little intimidating. Well, today we're going to demystify these two major research approaches. By the end of this video, you'll understand exactly what they are, how they differ, and when to use each one. So whether you're a law student, a social scientist, or just a curious mind, stick around. Let's start with the basics: focus and objective. Imagine you're a detective. A doctrinal legal researcher is like a detective who spends all their time in a library poring over law books, statutes, and old case files. Their mission is to understand the law as it's written. They want to know, what does this rule say? How has it been applied in court? Is there a consistent logic to it? They are essentially mapping out the legal landscape based on existing documents. The goal is clarity to interpret and explain the legal framework we already have. It's a theoretical deep dive into the letter of the law. Now, let's think about a qualitative researcher. This detective puts on their walking shoes and heads out into the streets. They don't want to just read the rules. They want to understand how those rules affect people's lives. They're interested in human behavior, experiences, and social phenomena. Instead of asking what is the law, they ask why do people act this way? Or how do they feel about this situation? Their objective is to explore the why and how behind human actions, gathering rich, descriptive stories that give context and meaning to real-world events. They're looking for the human story behind the statistics and the statutes. So how do these different goals shape their methods? This is where we see a major split in their toolkits. The doctrinal researcher's methodology is all about analysis of texts. They primarily work with primary legal sources like legislation and court decisions, and secondary sources such as scholarly articles and legal commentaries. Their main techniques are textual analysis, which is just a fancy way of saying they read legal texts very, very closely, and case law analysis, where they dissect past judicial rulings to find precedents and patterns. Sometimes they might even do a comparative analysis, looking at how laws differ between two countries. It's a very structured process focused on legal reasoning, not on collecting new data from the outside world. On the other hand, the qualitative researcher's methodology is all about gathering non-numerical data directly from people. Their toolkit is filled with methods designed to capture deep insights. They might conduct in-depth interviews or organize focus groups to hear first-hand accounts and opinions. They could become a participant observer, immersing themselves in a community to understand its culture from the inside. Or they might use content analysis to examine speeches, media, or documents to identify underlying themes and perspectives. The key here is that the data is descriptive and open-ended. It's about building a narrative from the ground up based on what they see and hear. This brings us to the data itself. What are they actually working with? For doctrinal legal research, the data sources are quite specific. Primary sources are the bedrock: laws passed by legislatures, judicial decisions from courts, and legal codes. Secondary sources, like legal textbooks and journal articles, provide commentary and analysis on those primary sources. A crucial point is that this data is generally static. A law passed in 1980 is still the same document today. The researcher isn't creating new data. They're interpreting what already exists. For qualitative research, the data is much more dynamic and is often created by the researcher themselves. Primary data comes from interviews, field notes from observations, video recordings, and survey responses with open-ended questions. It's fresh, direct information from the source. While they might use secondary data like published studies or books, they analyze it differently, perhaps looking for themes or perspectives to support their own primary findings. Because this data comes from people and real-world interactions, it's alive and can change depending on the context of the research. Now, how do they interpret this data? This is where their approaches really diverge. In doctrinal legal research, interpretation is normative. The researcher applies established principles of legal reasoning. They look at precedent, they analyze the logical structure of an argument, and they synthesize various legal principles to arrive at a conclusion. It's a systematic process that operates within the established framework of legal norms. The researcher's own feelings or experiences aren't the focus. The focus is on a logical and coherent interpretation of the legal text itself. In qualitative research, interpretation is all about understanding meaning from the perspective of the people being studied. It's inherently more subjective because it seeks to understand human experiences and perceptions. The analysis is often inductive, meaning the researcher starts with the raw data like interview transcripts and allows themes and patterns to emerge naturally. They aren't testing a pre-existing hypothesis in a rigid way. Instead, they're building a theory or an understanding from the ground up, using techniques like thematic coding or narrative analysis to uncover the deeper meanings hidden within the stories people tell. So, after all this work, what do they produce? What are the outcomes? The outcome of doctrinal legal research is typically a strong legal argument or a clarification of the law. This could be a paper that develops a new legal theory, identifies a gap or an ambiguity in a statute, or synthesizes existing case law to predict how a court might rule in a future case. It provides clarity and direction within the legal world. Think of it as creating a more detailed and accurate map for lawyers and judges to use. The outcome of qualitative research, however, looks quite different. It produces rich descriptions and deep insights into a social phenomenon. It might be a study that helps us understand complex social patterns, like why a certain community has a high level of trust in local government. It could lead to the development of a new theory based on real-world observations. Ultimately, it provides explanations for how and why things happen in the social world, giving us a textured, nuanced understanding of human behavior that numbers alone could never provide. Let's make this concrete with an example. Imagine we're researching the concept of freedom of expression. A doctrinal legal researcher would dive into constitutional law. They'd analyze landmark Supreme Court decisions, dissect the wording of relevant statutes, and trace how the legal definition of free speech has evolved over centuries. They might look for inconsistencies in different court rulings or argue for a new interpretation of the law. Their entire project would be based on legal texts. Now, how would a qualitative researcher tackle the same topic? They would go out and talk to people. They might conduct focus groups with journalists, artists, and activists to understand their personal views and experiences with freedom of expression. They could interview people from different cultural backgrounds to see how their communities view the balance between free speech and public safety. They would analyze the themes from these conversations, perhaps discovering that what freedom of expression means in a university classroom is very different from what it means on a factory floor. They are exploring the living, breathing social reality of the concept. So, to wrap it all up, doctrinal research is the what of the law. It's text-based, analytical, and aims to clarify legal rules from within the legal system. Qualitative research is the why and how of human experience. It's people-based, interpretive, and aims to understand social phenomena in their natural context. Both are incredibly valuable. You can't have a just legal system without rigorous doctrinal analysis to ensure our laws are coherent and clear, and you can't create effective laws without qualitative insights into how they will actually affect people's lives. They aren't competing. They are complementary tools for understanding our world. Thank you so much for joining me today. I hope this has cleared up the difference between doctrinal and qualitative research. If you found this video helpful, please give it a thumbs up and don't forget to subscribe for more deep dives into fascinating topics. Let me know in the comments if you have any questions or if there is another research method you'd like me to cover. See you in the next video.